Okay, the recording started. And we're now going to be at the council are going to come and introduce themselves to us. At the judges' chambers, you'll see in the background.
Council?
Okay. So if the council can come and introduce themselves.
Good day, my justice. I am Prosper Dumani, and I'll be appearing with my co-counsel on behalf of the applicant, who shall then also introduce herself.
Okay, where's your co-counsel?
Good day. Okay. Good day. I am the junior counsel for the applicant. I am Nomfundo Queen Mahlangu.
Yes, Ms. Mahlangu. Thank you, Mr. Dumani and Ms. Mahlangu, for introducing yourselves.
Thank you, Ms. Dumani and Ms. and co-counsel for introducing yourselves. Ms. Mahlangu.
Sorry?
Thank you for introducing yourselves.
Okay.
Thank you, my justice.
Thank you, my justice.
Thank you, Mr. Dumani and Ms. Mahlangu. Nice to meet you.
Nice to meet you. Thank you, my justice.
Look forward to seeing you in court.
And now for the respondents. Are you here? Counsel for the respondents.
Good morning, my justices. My name is Mili Pila, and I am standing in for the respondent together with my co-counsel, Ms. Teslin Lee, who will also introduce herself.
Okay, thank you, Ms. Pila. Ms. Lee, where's Ms. Lee?
Good morning, my justices. My name is Teslin Lee, and I am on the junior counsel for the respondent.
Okay, and thank you very much for introducing yourselves. And for the amicus. Is counsel for the amicus here?
Good day, my justices.
Yes, you can introduce yourself to us.
My name is Tashea Naidu, and I am appearing as the amicus curiae on behalf of the Abafazi Equality Institute.
Thank you, Ms. Naidu. Thank you for introducing. All of you are aware of the time periods that you are allocated. For senior counsel, we'll allow 10 minutes. It says uninterrupted, and for junior counsel, 7 minutes uninterrupted. Are you happy with that sort of protection?
Yes, thank you.
Okay. Thank you to all of you for coming to introduce yourselves. We will now go into court, and you will be able to present your cases. The applicants will start, and they'll produce their case. Then it's going to be the amicus curiae, and then it's going to be the respondent. Okay, thank you. We're now going to court. Okay, thank you very much. We're now in court. Will the registrar please call the matter?
Okay, in the matter between Mashaba Thandi, the applicant, and the Director of Public Prosecutions, who is the first respondent, the President of the Republic of South Africa, who is the second respondent, and the Minister of Cooperative Governance and Traditional Affairs, who is the third respondent. and the Abafazi Equality Institute, who is the amicus curiae in this matter before us today.
Thank you. Council.
Thank you, my justices. Good day once again. As interested in the chambers, I am Advocate Prosper Dumani, and I'll be appearing together with my co-counsel, Advocate Queen Mashang, and we both appear on behalf of the applicant. My justices, the matter before this court today is a challenge to the constitutional validity of the regulations, specifically Regulation 24.
Sorry, Mr. Dumani.
26,
sorry,
and,
Mr. Dumani. Before you proceed with introducing the matter, it's customary that you introduce yourself and your junior counsel. The respondents will have to stand up and do the same, and then the amicus the same. We are now in court session, so each one will have to go on record.
I will then begin the timer after the introductions, Advocate Bafa.
Yes. So for the respondents,
okay,
who appears for the respondent?
I appear for the respondent. As it pleases the court, my justices, my name is Millie Pila, and I appear for the respondent with my learned colleague, Ms. Teslin Lee.
Thank you. For the amicus?
As it pleases the court, my justices, my name is SHRC and I appear as the amicus curiae on behalf of Wathint'abafazi Equality Institute. Thank you.
Thank you. Mr. Dumani.
Thank you, Chief Justice. This is the court. I will then proceed.
Yes, please do.
My justices, the matter before this court today is a challenge to the constitutional validity of the regulations, specifically Regulation 24/2/26 and Regulation 31, as promulgated under the Disaster Management Act. The applicant challenges the constitutionality of the regulations on two grounds. The first being that the regulations constitute a violation of Section 10 right to human dignity and occupational freedom as enshrined in Section 22 of the Constitution in a manner that cannot be justified under Section 36 of the Constitution. On the second ground, the applicant challenges the constitutional validity of the regulations based on irrationality. As the lead counsel for the applicant, I will be dealing with the first ground, and my co-counsel will then be dealing with the second ground, and she shall then further deal with the remedies that the applicant seeks before this court. If it pleases the court, I shall then proceed with my submissions.
You may proceed, Mr. Dumani. You will, the registrar will notify you when the time is up.
Thank you, Chief Justice. The applicant submits before this court that the regulations violate the right to human dignity as enshrined in Section 10 of the Constitution. Section 10 of the Constitution provides that everyone has inherent dignity and they have their right to have their dignity respected and protected. It is important for the applicant to bring before the court that the right to human dignity overlaps with the normative zones of other personal rights found in the Constitution. For instance, the right to life, the right to privacy, and more relevant to this matter, occupational freedom, including the right to trade, the right to practice a trade, the right to choose a trade, and the right to earn a living. This was confirmed in the S versus Makwanyane case, whereby the Constitutional Court of the Republic of South Africa held that the right to life and the right to dignity are the most important of all human rights because they constitute the foundation upon which other personal rights found in the Bill of Rights are then constituted. This therefore follows that the right to human dignity my justices, can be violated by an act or a conduct, or as it is in this particular case, regulations that violate other personal rights in the Constitution in an area of overlap with the right to human dignity. The applicant therefore respectfully submits that the regulations, specifically Regulation 24.2 and 26, do violate occupational freedom in an area of overlap with the right of human dignity. Therefore, they constitute the violation of the right to human dignity. The applicant respectfully submits that the regulations affects these violations in two manners, which I'll then proceed to explain below. In the first place, it was contemplated in the Wathint'abafazi versus the Minister of Home Affairs case, whereby the court held that where a restriction upon the right to practice a trade amounts to a restriction on one's ability to earn a living and sustain themselves in a manner whereby they will be able to live without positive humiliation and degradation, that restriction of the right to trade also amounts to a restriction on human dignity. It is the submission of the applicant before this court, therefore, that by imposing a complete ban on the sale of alcohol and the operating of shebbeens, the regulations promulgated under the Disaster Management Act abrogates the applicant's ability to operate a business in a manner that so that she can earn income so as to sustain herself. This therefore puts her in a state whereby she is faced with a threat to the threat of a positive humiliation, which will be a continued state of existence till a period which is at this particular point in time undefinable, since the COVID virus has not yet attained the cure. Therefore, this constitutes a violation of a right to human dignity, because now the applicant is forced to be in a state of poverty, which is induced by an inability to earn income. She's also faced with destitution, which also, my justices, constitutes a violation of the right to human dignity. And in the third place, it is important for the court to be made aware of the fact that the applicant has 4 dependents who are all dependent on the income generated from the shebbeen, and those particular dependents, 3 of them are minors, and their rights as their children, their rights as children of the applicant are also impacted in that manner, since they won't be able to attain a standard of living which is dignified as envisioned by the provision of Section 10 of the Constitution. In the second manner, the right to human dignity is violated when one factors into consideration the relationship that exists between a person's work and that person's dignity. It was held in Affordable Medicine's case that the relationship between a person and his work is a foundation of a person's existence. This is further accentuated by the court in the Wathint'abafazi case mentioned above, whereby the court stated that the freedom to engage in productive work is indeed an important component of human dignity, because mankind is a social species with an instinct of meaningful association. We submit that the right to human dignity of the applicant is further violated in this manner, that the complete ban on the sale of alcohol and the operating of shebbeens restricts the applicant from carrying out what she considers as positive work, which is part of her identity, which is part of a sense of self-worth, which is part of her identity. Therefore, her inability to continue to run a business due to the restrictions has implications on her right to human dignity. I shall therefore proceed with the Section 36 analysis, in which I shall prove that the violation of the right to human dignity by the regulations is unjustifiable and it is also unreasonable. Section 36 of the Constitution allows only the limitation of rights wherein it is by way of law of general application, and that limitation must also be reasonable and justifiable. The applicant submits that when taking into consideration one of the factors that were established in S versus Makwanyane, and also have been included in Section 36 of the Constitution with regards to ascertaining whether the limitation is reasonable and justifiable. That is the nature and the extent of the limitation. The limitation imposed upon the applicant's right to human dignity and occupational freedom cannot be said to be reasonable. This is so because the test entails an assessment of the harm done by the regulations and the purpose which the regulation seeks to achieve. According to the submissions of the state in the papers which have been also brought before the court, the purpose of the limitation is to flatten the curve and to curb the spread of the virus. The applicant respectfully submits that when considering the purpose which the government seeks to achieve and the harm that has been done, the harm is severe to an extent that it cannot under any light be deemed to be reasonable and justifiable. The harm that has been done by the regulations is apparent, my justices, in that it is a complete ban on the sale of alcohol and the operating of shop-ins. It is not a restriction. It is a complete ban, which means that the applicant can no longer carry out her work. Therefore, the limitation on occupational freedom is actually severe in the fact that it's to an extent that it cannot, it's at an extent that it cannot exceed, since a total ban was imposed. As the right of human dignity is concerned, the violation or the restriction by the regulations is equally severe in that the applicant is left without any means of sustenance and is faced with positive humiliation and degradation, and further to that, a state of poverty, which is induced by these regulations. I respectfully submit before this court that the regulations are therefore, the extent of the limitation by the regulations is actually severe. In the light of the second factor, which the court must consider in determining reasonableness, the presence of less restrictive means, which I shall then list below, renders the limitation imposed by the regulations to be unreasonable and unjustifiable. The goal of flattening the curve could have as well been achieved by placing COVID-19 protocols, such as requiring those operating shop-ins to fumigate their premises, installing sanitizing stations, and barring those who display signs of COVID from entry. This would have achieved the goal of flattening the curve while maintaining less restriction. While this means maintaining less restriction on the rights of the applicant. My justices, if it pleases the court, may I please be allowed an extra minute to wrap up my argument?
Yes, you may. You may proceed for 1 minute extra.
Thank you, Chief Justice. The means stated above would have equally flattened the curve with less intrusion on occupational freedom and human dignity as compared to a complete ban. This has been evidenced in other countries that achieved this, such as New Zealand, whereby they did not put a complete ban on the sale of alcohol, but put certain measures in place, and the curve was well flattened, and the spread of the virus was also equally kept. My justices, the reasonableness test also requires that there be a rational connection between the purpose sought to be achieved and the means. The applicant submits that there is no connection, or more accurately, there is no proven connection between the sale of alcohol and the spread of the virus. And relying on the decision in S versus Makwanyane, whereby the court stated that when a right is being limited, it should not be done so in consideration of the fact that there may be a purpose which is sought to be achieved, but that purpose should be exact, and it should be clear that it will be achieved by the means which the government has imposed. In this case, the government has imposed the ban on the sale of alcohol and the operating of shebeens from an instance of a maybe, the purpose may be achieved by these means. I therefore respectfully submit before this court that the limitations on the right to human dignity and occupational freedom cannot be said to be reasonable because of the reasons that have been mentioned above. Thank you.
Thank you, Mr. Dumani. Thank you for your presentation. That was uninterrupted, Mr. Dumani. We're now going to engage with you in order to establish what we will ultimately have to give a judgment on. And namely, those are your propositions that you have made before the court, including your heads of argument. Mr. Dumani, you are aware that Section 36 is colloquially or more profanely known as the limitation clause in the Constitution. And so this ban on alcohol, you accept is a law of general application, is that correct?
Yes, my justices, we accept that the ban on alcohol by the regulations is a law of general application.
And you are arguing that this general application, it's the second stage in the argument of affordable medicines case, that you are saying that it is not reasonable or justifiable. Is that what you are arguing?
Yes, Chief Justice, the argument of the submissions of the applicant before this court is that in as much as the restrictions are a law of general application, they cannot be found to be reasonable or justifiable.
And when we have to deliberate on this matter, we have to establish whether your counter proposal, or rather your attack on the reasonableness or justifiability of this limitation is correct logically and factually. You suggest that firstly, alternative means can be used. Sorry, somebody speaking in the background.
Please,
sorry.
May everyone that is not addressing the court kindly turn off their microphones.
Thank you. Mr. Dumani, how do you suggest the government goes about? You have made submissions that they introduce aspects such as people checking for temperatures, ensuring that people who enter into shebeens, in this particular instance for your client, the applicant, that they introduce a protocol. And how is this protocol going to be monitored?
Thank you, Chief Justice, for the opportunity to develop that argument in that regard. The protocols shall be monitored in a manner that the government is currently monitoring other protocols which they've put in place. For instance, with regards to supermarkets and other places where there is gathering of people, and there is a need to ensure that the lockdown, the restrictions imposed, such as social distancing and the presence of sanitizing stations are installed. Therefore, I respectfully submit before this court that this can also be achieved, and it should be the case because a complete ban in this case is severe to the applicant's right to the applicant's freedom of occupation, as well as by implication her right to human dignity. The installation of the sanitizing stations and the requiring Shabins to fumigate their business premises, if it is enforced in the same way that the government is currently enforcing these measures upon those who are running supermarkets and other forms of business, whereby there is the gathering of people, ensuring that social distance is maintained. This is an alternative, less restrictive means that can also achieve the purpose of flattening the curve.
So, yes, sorry.
Sorry, Your Justice. Mr. Tumani, I just wanted to ask you, if you said that they were going to implement sanitizing stations, etc., who's going to police this? How and at whose costs will this be installed?
Thank you, my Justice. As made in the submissions, the Shabin owners shall bear the burden of ensuring that these stations are installed, as it is the case with other forms of business which are currently operating under, which have operated and are currently operating under the lockdown regulations. This, my Justice, presents a less restrictive means in that it only affects the applicant or the shipping owners at large, in as far as they will then have to install the sanitizing stations at a mere cost, as compared to them not operating their businesses, therefore not earning any income, and being faced with the possibility of destitution and the inability to live a life dignified, envisioned by the drafters of the Constitution when they put up in the Bill of Rights the right to life.
That may answer the question as to who will install the sanitization, but you haven't answered my question on the question of who will police this, and if that policing is, what is the accuracy of this policing? You must realize that this is a world pandemic. The thought process behind the complete lockdown and the banning of alcohol and the restriction of the human rights as they are in this particular case is to ensure that people are safe. How do you propose that this safe will be implemented?
My Justice, I would like to draw your attention to the fact that out of all the countries in the world that have experienced the COVID-19 virus, only 4, namely South Africa, Botswana, and Panama, have implemented the complete ban on alcohol. But countries such as Canada and the United Kingdom have actually encouraged the sale of alcohol during this particular period, and they have also successfully managed to make sure that people are safe. If people were exposed to the virus, it was not necessarily in relation to the consumption of alcohol. There has not been any solid evidence which can be reasonably relied upon to say that restricting the sale of alcohol has contribution towards the safety of the people. With regards to the policing, this can then be developed by the responsible authorities, but taking heed to the measures that have been implemented in other countries. Since you've mentioned, and rightly so, my Justice, that this is a world pandemic and it has been experienced everywhere. Therefore, the authorities, or rather the responsible policing institutions of this country will then have to maybe take examples from certain countries which have which are successfully policing these measures that I've mentioned above. I've also already mentioned the countries in which they can take a lead from.
Is that not adding extra burden to the already overburdened police services and monitoring services of the country with the pandemic that we're having currently?
I respectfully submit, my Justice, that it is a better measure in the sense that the current measure which has been imposed, that is the complete ban, it places more emphasis, or rather more burden, on the general public, which are, as the case is with the applicant, the most vulnerable of our societies. That is, in this instance, a single mother with 4 dependents. I would respectfully submit before this court that the burden is better borne by the government, who is basically the custodian of the rights of the people, and also the safety of the people, instead of shifting the burden from the responsible authorities to private citizens.
Mr. Dumani, can I ask you this following question? Is the applicant's case, does it not fall short in the sense that there is a double-barreled aspect here, and the applicant is only addressing one aspect? The second aspect to this, the first one is the ban on the sale of alcohol. The second one is to ban gatherings which take place at a shebeen, of which your client is an owner. And these gatherings are known as what they are commonly referred to as spreader events or virus spreading events. I do not find that the applicant has sufficiently dealt with the issue of gatherings, while it has only concentrated on one aspect, namely the ban on the sale of alcohol. You see the regulations posit a position where shebeens or gatherings at shebeens can be banned. And that aspect the applicant has not covered. And I see your argument is still primarily focused on one aspect, and that is the ban on the sale of alcohol.
I concur, Chief Justice.
If I may add, just before you respond, Mr. Dumani, if I may just add, in addition to what the Chief Justice has indicated, another ban which you have not, which the applicant has not addressed, is the ban on travel, both local and international. One of the arguments that you've raised is the fact that the ban on alcohol will result in both loss in patronage of international and local consumers of alcohol. However, taking into account that under level 4, only a certain type of people are allowed to travel, that not everybody is able to travel. How do you deal with that aspect? Just on that one. You may go ahead, Mr. Dumani.
Okay, thank you, my Justices. To respond to that, the question posed by the Chief Justice with regards to the ban on the gatherings, I'll deal with it briefly, but I would like to indicate to this court that it is also dealt with when we are then considering the rationality of the decision. That is the submissions that my co-counsel is going to make. But with regards to the gatherings, I would like to draw this court attention to the De Beers case, which also dealt with the lockdown regulations. It was held in the High Court of South Africa, and it was a challenge to the whole declaration of the state of disaster and the invoking of the Disaster Management Act. The judge reasoned that the people who are similarly placed as the applicant is, who are operating their private businesses, are now then being forced to stop completely from operating their businesses. And as a result, because they no longer have any means of income, they are now forced to rely on social assistance, which is provided by the government. But the process in which the applicant is then expected to go through in obtaining such social assistance includes the queuing in long queues, and sometimes the judge highlighted, it's for days and sometimes it's for hours. While they're queuing there, it is a common cause that the applicant won't be queuing alone, but there will also be a throng or masses of people also queuing up for the same social funding. So therefore, the applicant respectfully submits before this court that the ban on operating Shabins.
Sorry, Mr. Dumani, we're not asking you to address us on the Solidarity Fund. That's not the issue that is currently. The question that I want answered in order for us to make a decision is that we have to balance what will happen to the South African general population as opposed to your client's individual ability to earn an income. And we need to balance those factors in order to make a decision. The question that I pose to you is, as far as a gathering is concerned where people are imbibing alcohol and people are known to get out of control, we can take judicial notice of the fact that people, when they get drunk, will not abide by rules of keeping the masks on or sanitizing. What the question is that while you have addressed the issue of the ban of alcohol, you have not at any stage addressed us on the gathering, and neither has the applicant in its heads and currently before us indicated why it would be reasonable and in the balancing act in terms of Section 36 that this gathering aspect where other people's lives are placed at risk. So for example, a person goes and drinks at the shebeen, goes home and contracts the virus at the shebeen and then spreads it to the entire family. We need to take the consideration of the family, the community, the citizenry of South Africa. So what do you say about that specific aspect that I've asked about, namely the gatherings of people where they are drinking alcohol and they're spreading the virus?
Thank you, Chief Justice. I respectfully submit that under the analysis or the consideration of the less restrictive means, the applicant has also highlighted in the heads of arguments that there is a less restrictive means of achieving what the Chief Justice is indicating above, that can be achieved by ensuring that there is a certain acceptable number of people within the premise at a particular time, depending on the size of the premises, and also another.
Mr. Dumani, have you ever tried to reason with the person who's drunk?
I have not, my Chief Justice, but in that regard, I also indicated that there can be a limit on the minimum amount of alcohol that a person can then consume upon those premises, and all these, my Chief Justice, will be the responsibility of the shebeen owner. I respectfully submit that this constitutes a restrictive means in that the burden of ensuring that these measures are taken into consideration is far much better than having the applicant not operate a business at all due to the
Mr.
complete
Dumani,
ban.
Mr. Dumani, you must be aware, and I'm not sure whether your client is registered for SARS or whatever, but a lot of these shebeens operate without them being registered. There is no control over the shebeens as such, apart from the purchasing a license of as far as alcohol, and even in those instances, there are problems. So how, if already on just the purchasing aspect of a shebeen is problematic, don't you think that your proposition that they will allow to self-regulate is problematic?
I respectfully submit that the proposition is not problematic, Chief Justice. The first consideration is that the applicant in this case is actually a registered shebeen owner. And then in the second place, this then calls for the measures which I was referring to above, my Chief Justice, which deal with the policing, therefore, of the proposed measures. Thus, instead of imposing a complete ban, the applicant respectfully submits that a better regulation of the operating of shebeen on the premises constitute a less restrictive means, which can also equally achieve the purpose, while ensuring that the government does not induce the applicant and similarly placed individuals in a state of poverty, which is induced by the government's regulations.
Mr. Dumani, can you address us on the allegations or the argument that says that the likely accidents or injuries that that would result from inducing alcohol would exhaust the already overburdened hospitals, which are supposed or which should be focusing on the pandemic?
Thank you, my Justice. In the first place, I would like to respectfully submit before this court that it is an unfounded or ungrounded allegation which is being made that the decrease on the road accidents and the crime rate in South Africa are due to the ban which has been imposed on alcohol. This comes into light when one considers that, as I have indicated above, among all the countries which have experienced the COVID-19 outbreak, only 4 countries have actually put a ban or imposed a ban on the sale of alcohol. A country which statistically speaking is known for high crime rates, which are related to homicide and assault, is Colombia. And that particular country, my Justice, actually did not impose a ban on the sale of alcohol, but then it also, according to the statistics gathered by the WHO, have also experienced a 55% decrease on homicides and an 86% decrease on assaults. I respectfully submit, therefore, that there is no rational connection that can be established between the banning of alcohol and the situation in the hospitals. Actually, more accurately, the reduction in the road accidents and the decrease in crime is more associated to the fact that is more associated to the social distancing which has been imposed by the governments of states all over the world. This is a logical reasoning in that if there are less people in public, there will therefore be less contact with those particular people, and therefore it follows that there will be less accidents in that regards. So it has nothing to do with the restriction that has been imposed on alcohol. It will be falsely to attribute those statistics to alcohol only.
Mr. Dumani, you've used Colombia as an example, is that correct?
Yes, Chief Justice.
Do you know Colombia has got over approximately 1.4 million confirmed cases of the virus, as compared to South Africa, which has got about 830,000 confirmed cases. So it's almost double the amount of coronavirus infections in Colombia. How does that now support your proposition that we should allow the South African citizenry to be subjected to the same threats or same exposure as has been experienced by the citizens of Colombia? You are asking us to make a ruling that will place the citizenry at threat.
Thank you, Chief Justice. I am rightly aware of those statistics with regards to the virus situation in Colombia. However, I respectfully point out to this court that the reason why I cited or made Colombia as an example, it was in relation to the fact that the crime rate, which has also been by the respondents attributed to the filling in of hospitals, is untrue. I refer to Colombia because it is a country which statistically has been recorded as the one which has records of high levels of homicide worldwide, and high levels of cases of assault as well. However, with regards to the fact that there are cases of the COVID virus are higher than that of South Africa, I respectfully submit before this court that I am not saying that this court should consider the situation of Colombia as a whole, in the sense that there are other attributes that could have been the cause of the higher numbers of the COVID virus as opposed to South Africa, which in this case, they have not yet been placed before this court.
So yes, so you would agree that there are no statistics before this court, and you are asking us to make a decision which will pose a risk to the citizens of this country.
I respectfully submit before this court, my justice, that the propositions that I've made before this court are not to put the citizens at risk. In that,
but you agree that that will be the effect. You may not be asking, but the effect of it will be that we will be in the same position as Colombia, and you don't have statistics to show us whether it's alcohol related or not.
I respectfully disagree that will be the effect, because as I have indicated that the high numbers of the COVID virus could also be attributed to by other reasons which are not alcohol related. But as I also,
sorry, Mr. Dumani, that is a proposition which is untested, which we cannot test, which you are making from the bar, which has no statistical basis, and you are asking that to be used as an example, but yet you cannot provide any statistics.
My Chief Justice, I referred to the statistics with regards to the crime rate in addressing the question, in addressing the allegation that the hospitals have been filled due to the trauma, rather the trauma units have been filled due to accidents and the crime that is alcohol related. And in this particular instance, the statistics which I referred to with regards to Colombia, they prove otherwise, in that Colombia did not actually impose a ban on the sale of alcohol. However, with regards to the crimes that lead to people being in trauma units, as alleged by the respondents, those crimes have actually decreased in as much as the alcohol ban was not imposed upon the state. Therefore,
you don't even know, Mr. Dumani, it's whether there's lesser social interaction that may have led to the decrease in those crimes.
My Justice, if I could get that question again.
Sorry, I say we do not even know whether the decrease in social contact between people has led to that result. Why do you attribute it solely to the absence of, or rather the presence of alcohol that did not increase those instances? What I'm trying to say is that if there is no social contact, if I want to stab somebody and I don't meet the person, I can't stab the person. So what weight do we place on this, on these propositions that you make and attribute those incidences to be happening despite the presence of alcohol? The issue is fundamentally is that we don't have statistics. And the applicant hasn't produced any statistics in its heads of argument, and neither can you from the bar, apart from making a conclusion which is unverified.
Thank you, my Chief Justice. I will therefore withdraw that submission that I've made from the bar with regards to the Columbia statistics.
Are there any other questions for Mr. Dumani?
One last question, Mr. Dum.
Thank you, Justice. Mr. Dumani, can you just address us on the point that you've made about the ineffectiveness of the Solidarity Fund as a remedy?
Thank you, my Justice. The applicant submits that the Solidarity Fund does not constitute appropriate social relief for the applicants in as far as the violation of her freedom of occupation and the right to human dignity is concerned. The applicant has cited two reasons for this. The first being that the violations the regulations infringe the applicant's right to trade, which is a component of occupational freedom. And as indicated above, that component of freedom also is a component of human dignity. In the first place, the Solidarity Fund does not address the aspect of the applicant being able to carry out her work, which, as I have identified above, is part of her identity and therefore indeed her dignity. Thus, even if the Solidarity Fund is provided to rather generate income or to give income or to give sustenance to the applicant is still unable to work, and in the presence of the regulations that completely ban her ability to work, to carry out a trade, which as indicated is part of her identity, the Solidarity Fund therefore does not sufficiently address that aspect. In the second instance, even if the Solidarity Fund is a means of giving the applicant another source of income or another means of sustenance, it is filled with notable defects that makes it insufficient as a social relief for the applicant. One of those reasons that I've mentioned above is that the application or processing an application for the Solidarity Fund is not a guarantee that the applicant will actually get the funding. And as submitted in the heads of argument, the applicant draws this court's attention to the fact that in a report submitted by the Solidarity Fund for the month of September, excuse me, my Justice, as indicated by the report for the month of September, funding did not come with guarantee that one would receive such funding. Applying for funding did not come with the guarantee that one receives such funding. And according to the Food Voucher Relief Program Summary Report, that is the report that I'm referring to, the one for September, only 135 parcels were food parcels were available for and prepared for distribution. Furthermore, when considering that the income that the business of the applicant was generating before the lockdown restrictions had been implemented, it therefore also comes to the cost attention that it is the Solidarity Fund is actually a far cry from being an appropriate social relief. It is noted that the food products which were provided for the applicants or the individuals similarly placed as the applicant was worth of 700 rands, and that is on a monthly basis. Therefore, I respectfully submit before this court that if the existence of the Solidarity Fund does not constitute appropriate social relief, that we can say that it remedies the regulations from unconstitutionality.
So Tubisani, could you tell a court exactly what steps did your client take to approach the Solidarity Fund, and what were the results of any steps that she did take?
My Justice, I respectfully submit that the applicant did not take any steps, and this also brings into light the other defects that I highlighted in the heads of argument with regards to the Solidarity Fund being not able to remedy the regulations from unconstitutionality. It is the applicant's submission that the process with regards to the administration and to the assets of the Solidarity Fund was actually not well put out to the public as information that can be processed easily. Secondly, the application process on its own was not clearly outlined for the applicant to therefore process the information and act on it.
Is it not correct for your client to have, for the applicant to have ascertained what her rights were before approaching the courts and burdening the judiciary with litigation, which could have been circumvented had she ascertained that there were alternative options for her to get relief?
My Justice, if I may, if it pleases the court, may I have that question again?
The question I'm posing is that the applicant has now approached the Constitutional Court for on a constitutional question that her rights have been affected, and her rights to dignity, her rights to trade have been affected. The government has provided options in the pandemic, in the declaration of the pandemic, they've provided options, i.e. the Solidarity Fund. Now, that's an option that you can exercise and you can go and get assistance from, and you exhaust that first before you come to court and then burden the judiciary with litigation, which could have been dealt with if she had went to the Solidarity Fund before, or looked at her or investigated her options before coming to court. So that's my question. What did she do to ameliorate her losses before she came to the Constitutional Court?
My Justice, I respectfully submit that the applicant did not take any steps, and in as much as she would have taken any steps, the Solidarity Fund set up by the government would have, even if she had been able to access it, it is the applicant's submission that it does not remedy the regulations from being unconstitutional. This is in line with the reasoning in the De Beers case. The respondents, they had argued that the government had put in place measures such as the Solidarity Fund to that effect, but the judge reasoned that rather the court held that there are certain rights, such as in this case the right to human dignity, which cannot be remedied by monetary recompense. That is why, therefore, the applicant is approaching the Constitutional Court, because the presence of the fidelity of the Solidarity Fund does not affect the constitutionality of the remedies in as far as they abrogate her right to trade, and also by implication her right to human dignity.
Thank you, Mr. Dumani. Thank you, Mr. Dumani.
If there are no further questions, then we will go on to the Junior Counsel, Ms. Mahlangu. And
Thank you,
she will be allowed 7 minutes to present her case uninterrupted, and then we will then engage with Ms. Mahlangu after that.
If it pleases the court, my justice, I would proceed to issue 4, dealing with the irrationality of the decision of the executive.
Thank you, Ms. Mahlangu. You may proceed.
The applicant submits that if the regulations are found to have infringed the human rights and the occupational rights of the applicant to be declared unconstitutional, on the basis that this court is empowered to consider the rationality of the decision based on the legality principle. The decision of the minister is an example of public power, which has to comply with the Constitution. In support of the statement in the pharmaceutical case, it was stated that rationality is the minimum standard for the legality for all legal regulations. Therefore, the decision to ban and prohibit the sale of alcohol and the operation of shipping is required to be rationally related to the achievement of the objectives of the minister's decision. I would also want to say that this decision was procedurally irrational. The case Democratic Alliance versus President of South Africa stated that a rational decision is one that achieves its purpose. Hence, it is seen as the evaluation between the relationship of means and end. In the case Allied Center for the Study of Violence and Reconciliation, the decision was not connected to the purpose that was aimed to be achieved. The families and the victims were not given the opportunity to be heard. So in this matter, my justice, before the court, the minister made this decision based on expert evidence and the World Health recommendations, which is irrational because the decision would work effectively in first world countries. However, what about third world countries that have high rate of poverty and many communities get affected by this decision? We have to take into consideration that many families rely on the operating of shebeens and the sale of alcohol to make a living for themselves. I support this claim by the publication of Maverick that reported in South Africa, there are 34,507 owners, which have more than 200,000 dependents, and there are 10,000 shebeen permit holders. Therefore, my justice, this decision to close shebeens is irrational because it's not rationally related to flattening the curve and curbing the spread of the virus. Families have to queue for food and monetary handouts, and this exposes them to contracting the virus. Yet, the decision to implement this decision was to limit the spread of the virus. For these reasons, the decision to prohibit the operating of shebeens and similar establishment is irrational. If it pleases the court, my justice, I'll proceed to the remedies. Section 172 of the Constitution allows the court to declare a law or any conduct that is inconsistent with the Constitution to be invalid. Therefore, the regulations 24(2), 26, and 31 should be declared invalid based on the reason that they violate Section 22 and Section 10 of the Constitution and the irrationality reasons that have been discussed. I would therefore ask that there should be a suspension for the regulations for 2 months, and during those 2 months for the minister to remedy the defects. Meanwhile, we also seek for an interim order to protect people from the arrest and prosecution on the grounds of the regularities that are found to be invalid. And I support this by Force versus Minister of Safety and Security, when it held that when there is an infringement of rights, the law can be effectively cleared. Therefore, my justice, the applicant seeks these orders that for the regularities 24(2), 26, and 31 to be declared unconstitutional, to clear criminal records for those arrested for contravening the regulations that have been discussed above, and allow the sale of alcohol and the operation of shebeens subject to social distancing measures. Furthermore, for the first to the third respondent to pay the legal cost and also the cost of the 2 counsels. If it is found that the application is unsuccessful, for the applicant not to be ordered to pay any cost based on the by-wage principle. My justice, this is all that I submit to the court.
Thank you, Ms. Mashlangu. You came in well within the time allocated to you for uninterrupted. We'll ask you, if we'll engage with you now to ask you a few questions for clarity. On the irrationality test, I have 2 questions. Firstly, on the irrationality test, and the second element is the Section 172 declaration in terms of the Constitution. So on the irrationality test, your basis is that because it's forcing people to queue for food for hours and sometimes days for food and monetary handouts, it therefore is irrational, and it might work in first world countries and not in third world countries, if I understand your proposition to be correct.
Yes, my justice.
So, Ms. Mashlangu, would a person rather queue for food or be dead? And that is the choice that we have to consider. So if not dead, then at the very least subject themselves to being hospitalized for days, if not months on end. And that is the one balancing factor we need to, so I would like you to address that aspect. As far as your Section 172 is concerned, that is correct that you say that in terms of the Constitution, that the court has the power to declare any law or conduct that is inconsistent with the Constitution as invalid, but the last portion you left out, and that is to the extent of it, the inconsistency only. So in terms of Section 36 first, how do we carry out that balancing act on the irrationality? I mean, you're aware of De Beer's case and Makonyani's case, and if you can address those two questions that I have as concerns.
With the first question, the reason why we submitted that it is irrational for them to be queuing for monetary and food handouts is because the main aim of implementing the regulations was to curb the spread of the virus. But if people now have to go for queuing, it exposes them to the virus because they are in contact with other people that they're not aware that could have the virus. Therefore, it doesn't make sense to implement these regulations at the same time to say people need to go and queue since they can't get a living by operating shebeens.
But there is no evidence before us that the government has not been applying social distancing in such queuing. If there is social distancing in such queuing, how are they exposed?
My justice, some people do not adhere to the necessary measures of the COVID-19 virus. some people remove their mask in public. So there's many factors that can contribute to them contracting the virus, and also the use of public transport if it happens to be so.
And then the section 172, thank you for that, Ms. Mashlangu. The extent of the inconsistency, to what extent do you say these regulations promulgated are inconsistent? And obviously linked to that is why such a short period? You know, our courts have allowed 18 months. And you are asking, the applicant is asking for only a period of 3 months that, that these regulations be looked at and redrafted.
The regulations are inconsistent with the Constitution to the extent that they subjecting the applicant as well as her dependents to poverty, which is degradational to their human dignity. Therefore, to that extent, I would say the regulations are inconsistent. Whereas if she would have been allowed to sell alcohol, she would have means to sustain her needs as well as the needs of her dependents.
Thank you, Ms. Mashlangu. Any other questions for Ms. Mashlangu?
Ms. Mashlangu, just to use your argument that not everybody adheres to social distancing, does that argument not also work against you in that the possibility of people who have consumed alcohol would be more prone to not ensuring that there is social distancing and actually removing the mask, in fact, to the extent of a possible infection of your client's children, who some of them are minor children and vulnerable? What is your response to that?
My response is that, like, as I have submitted, that one of the orders that we seek is for the sale of alcohol, is to allow the applicant to sell alcohol subject to the fact that the people that come and buy can just buy the alcohol and go from the premise where the alcohol is sold, since that people are not allowed to be in public areas.
Yes. Thank you.
Ms. Mashlangu, I hear your argument on the question of the irrationality of the ban of the alcohol. The World Health Organization has recognized that alcohol consumption is especially hazardous and harmful and a major contributor to intimate partner violence. What are your, if you're saying it's so irrational, and especially in South Africa, apparently the records show that 65% of women experiencing spousal abuse, and it's been reported that that spousal abuse has been due to alcohol consumption. Now, you're saying it's irrational to ban alcohol, but just taking into consideration the question of intimate partner violence and the connection with alcohol consumption and the statistics of the high levels in South Africa, what are your views on that?
My Justice, in terms of the statistics, I would like to say that the statistics were usually taken before we even went into a lockdown, the state of national disaster, the lockdown. Therefore, those and then the statistics that were taken during the lockdown, it also during there was the ban of the alcohol, there were also high statistics of the level of domestic violence within households. Therefore, this shows that even though the alcohol wasn't allowed to be sold or consumed, the violence increased. So we cannot say that alcohol is a factor that yes, it does contribute, but it's not a factor that can be relied on to say it contributes to domestic violence, because even though it wasn't sold during the lockdown, the cases of violence were increasingly very high.
But you agree that, I mean, with the lockdown, there was lots of cabin fever and people were very angry, and possibly that led to lots of abuse. But one could almost take judicial notice of the fact that the consumption of alcohol on a general probability has been a precursor for intimate partner violence, lockdown or no lockdown. Your thoughts?
Yes, my Justice, I do agree that it does contribute to violence. But in this manner where we seek for the applicant to be allowed the order to sell alcohol, I would support this claim by saying that the ban of alcohol is not linked to violence in the same way that the statistics for violence did increase very high whilst there was the ban of the alcohol. This shows that the violence, we can't say it's wholly reliant on the factors of having alcohol sold, because there are other factors that contribute to the violence which were seen in the lockdown, in the period of the lockdown. So it can be mental health issues, people being closed up in the same area for a long time, and frustrations. So we can't say alcohol contributed to violence during the lockdown.
I'm not suggesting that it is the sole contributor to the intimate partner violence. What I'm suggesting is that the consumption of alcohol, together with the unusual cabin fever that lockdown has imposed on the citizenry of the country, does the consumption of, would you agree that the consumption of alcohol together with the cabin fever could possibly be a precursor of higher levels of intimate partner violence?
Yes, my Justice, I agree.
Thank you,
Thank you. Ms. Mashlangu, you have not addressed us on the issue as to why the criminal records have to be expunged.
Because if the regulations are found to be invalid based on Section 172 of the Constitution, that means initially since the rights of the applicant were infringed, the record have to be cleared, because what she did, it was based on the reason to provide for her family and to not be subjected to poverty.
Thank you, Ms. Mashlangu. Any further questions for Ms. Mashlangu?
No other questions.
No more questions.
Thank you. We will now go to the respondent. Thank you, Ms. Mashlangu. We will now ask Ms. Bila for the respondent. Sorry, before we go, no, we have to go to the amicus before we go to the respondent. So Ms. Naidu for the amicus.
Good day, my Justice.
Yes, Ms. Naidu.
If it pleases the court, counsels for the amicus curiae will deal with two issues. Firstly, the limitation placed on the applicant's right to dignity is justifiable and constitutionally valid. Secondly, whether the correlation between domestic violence and alcohol consumption justifies the ban on liquor.
Sure, Ms. Naidu, can we get your video? If you can switch your video on so we could see you.
Yes.
If it's possible. Thank you. Thank you, Ms. Naidu. You may proceed.
Thank you, my Justice. The counsel for the amicus curiae respectfully submits that the alcohol ban and limitation on the applicant's right to dignity is constitutionally valid because it is rationally connected to slowing the rate of infection and limiting the spread thereof. Hence, counsel respectfully submits that the regulations justifiably limit the right to dignity of the applicant as guaranteed in the Bill of Rights contained in the Constitution. First, the Council for the Amicus Curiae respectfully submits that the lockdown regulations do not infringe on the applicant's right to human dignity as stated in Section 10 of the Constitution. Indeed, there is a core to the individual conscience so intrinsic to the human personality's dignity that it is difficult to imagine any factors that could justify that the state is penetrating it. Simplistically, the announcement of the lockdown protocols was not directed at the applicant with the sole purpose of limiting her rights, but rather with the purpose of significantly reducing the transmission of this life-threatening virus. Excuse me. On the eve of Thursday, 29th April 2020, the Minister of Cooperative Government and Traditional Affairs, in terms of the Disaster Management Act 57 of 2002, Dr. Dlamini Zuma, published the Alert Level 4 regulations. Section 27 is relevant to this case. Dealing with the liquor ban first, Section 27(2)(1) of the Disaster Management Act indicates that the minister may issue regulations or directions concerning the suspension or limitation of the sale, dispensing, or transportation of alcoholic beverages in the disaster-stricken or threatened area. It is first important to note that an individual's constitutional rights and freedoms are not absolute and are subject to limitation as per Section 36 of the Constitution. However, the limitation must employ a law of general application and determining what is fair and reasonable in an exercise of proportionality involving the weighing up of various factors in a balancing exercise to determine whether or not the limitation is reasonable and justifiable in an open and democratic society founded on human dignity, equality, and freedom. The decision of the minister is considered rational in the context of an objective test because under the circumstances, the means justify the ends, and hence the limitation of the aforementioned constitutional rights is justified in the context of Section 36 of the Constitution. Considering the nature of the pandemic, it is apparent that the minister is within her powers to regulate alcohol sales, even though it amounts to a complete ban. The Disaster Management Act authorizes the ban, and as long as it is rationally related to the purpose of the declaration of the disaster, it will be valid. The ban can be considered a strategy implemented by the government with the purpose of turning a public health emergency into a matter of law and order in the eyes of the public. The argument that liquor generates significant revenue for the country would not stand valid when the country's health infrastructure is fighting an unprecedented global pandemic, and the act of government to lift the ban is contrary to the preamble of the Disaster Management Act, which talks about the effective management of the disaster. The applicants claim that she is unable to earn an income and hence provide for her family lacks a legal framework because she had alternatives that she could have resorted to before contravening lockdown regulations. The Solidarity Fund was a widely publicized governmental initiative, and hence it is submitted that the applicant should have made a reasonable attempt to locate means to provide for a family that do not contravene the Constitution. Hence, my justices, it is respectfully submitted that lockdown regulations do not infringe the right to human dignity. The conduct of contravening lockdown regulations is what leads to the infringement of the right to dignity through arrest, which is inevitable. The social implications of the absence of lockdown measures justify subjecting the applicant to the inability to sell alcohol during the lockdown period. Alcohol cannot be considered a necessity, and hence the sale and consumption of alcohol exposes individuals to unnecessary risks of contracting the virus. The government must take every decision to reduce the unnecessary burden on the health system of the country to ensure that people who are unknowingly contracted with the virus can utilize the necessary healthcare facilities in the best possible manner. The lifting of the ban on liquor sales would be counterproductive to the government's effort to curb the virus's spread by making an alcoholic consumer more prone to the virus. Hence, daily significant cases and the increasing number of people being admitted to hospital illustrate that the minister made a rational and justifiable decision when banning the sale of alcohol. Implicitly, these means justify the ends because such means constitute a permissible limitation of a South African citizen's rights. Secondly, the Council for Amicus Curiae would like to discuss the correlation between the alcohol ban and intimate partner violence. Alcohol has many side effects on the individual and society as an entirety, which have become a primary concern during lockdown. During the lockdown, reports of domestic violence have soared across the world. As a country where 7 women are killed every day and a reported 40 to 50% of men have admitted to perpetrating physical partner violence, South Africa was already tackling an epidemic in domestic violence before the onset of the lockdown. Council respectfully acknowledges that while alcohol is not a sole contributor to intimate partner violence, Council respectfully submits that in a rhetorical context, the elimination of a single factor is saving thousands of women's lives. Contemporary literature further illustrates that a ban on alcohol significantly reduces domestic violence cases during lockdown. Council acknowledges the legal obligation of the state to protect the health of an individual from the ill consumption of liquor and safeguard the females from acts of domestic violence. Social science literature further corroborates this perspective. It is further conceivable that fewer domestic incidents would mean less pressure on trauma wards and less pressure on the medical staff. This is a valid argument and in a social framework meets the legal threshold of proportionality. Hence, it is imperative that South Africa ensure that they employ and prioritize a gender-responsive strategy within their COVID-19 response for the duration of the pandemic. One of these proposed measures would encompass the prohibition of alcohol. If they fail to do so and instead choose to deprioritize gender-based violence during this crucial time, the overall indirect death toll from COVID-19 will be significantly higher. The World Health Organization recognizes that alcohol consumption, especially at harmful and hazardous levels, is a major contributor to the occurrence of intimate partner violence and records that in South Africa, 65% of women experience spousal abuse within the last year. Reported that their partners always or sometimes drank alcohol before the assault. Hence, the Council respectfully submits that the implementation of an alcohol ban with the supplementary purpose of reducing domestic violence is effective and encouraged. My Justices, Council would like to conclude by stating that the aforementioned regulations is considered rational, constitutional, and valid because prohibiting the sale of alcohol and consequent gathering is one of the reasons that the burden on the healthcare system is reduced. Furthermore, these regulations cannot be lifted because such would make the implication that the consumption of alcohol takes precedence over the healthcare of a country. It is the position of the Council for the Amicus Curiae that the urgent and drastic measures implemented are necessary to curb the infection rate and to manage the healthcare system to prevent it from being wholly overwhelmed and subsequently collapsing. Thank you.
Thank you, Ms. Naidu. Ms. Naidu, the applicants have made out a case that the applicant's right to dignity has been severely dealt a blow with by these regulations, and in fact, it infringes the right of dignity. The applicant states that whereas the applicant was a breadwinner for the family, feeding herself, feeding the children, has now been basically brought to a beggar status, and that the Solidarity Fund is not of much assistance, apart from the fact that it leads to queuing, it will not lead to sufficient monies being obtained. How do you justify that breach of the right of such a right, and how can we uphold as a constitutional court that infringement?
Thank you for your question, my Justice. Council respectfully submits that it is not an infringement on a right to dignity, and if it is, the limitation on the right to the applicant's dignity is justifiable. The core purpose of the government is to protect the healthcare of South Africans as an entirety, and therefore limiting the rights of an individual or every individual, in fact, who sells alcohol is justifiable to ensure that for the greater good, which is what not only the South African Constitution is based on, but also informal principles that are integrated into the Constitution, such as Ubuntu or boni mores of the community. It would be in the best interest of the community and South Africa as an entirety to have the applicant's right limited, to ensure that lives can be preserved to the best possible extent on the part of the government. We need to take into consideration that the government is at all times acting in the best interest of all citizens of South Africa. And if we were to apply the court's perspective in regarding that the applicant is unable to provide for her family, counsel submits that this is unjustified, because taking into that perspective, one can argue that criminals or individuals rather who choose to engage in criminal activities are justified in doing so because they are unable to provide for their family because due to the rate of unemployment. So is the court to believe that, excuse me, Your Justice, is it justifiable to assert that simply because one is unable to provide for their family that they are justified in contravening the Constitution?
Thank you.
Thank you, Ms. Naidu.
Any further questions?
No questions.
No questions.
No further questions. Thank you, Ms. Naidu.
Thank you, Your Justice.
We'll now have Bila for the respondent.
As it pleases the court, I would like to comment. Okay.
You have 10 minutes uninterrupted, so we will listen to you for 10 minutes.
Okay, if it pleases the court, I would like to comment with my submissions.
Please do.
Okay. The applicant highlights a lot on what constitutes to human dignity. Ours is to contend whether an infringement of the right to human dignity has been imposed by lockdown regulations. The respondents submit that lockdown regulations do not infringe upon the right to human dignity. Under the circumstances of a pandemic being declared, it meant that states had to take urgent measures to protect life and to provide the best healthcare to all in need. This could be possible only by flattening the curve. Following this, South Africa declared a national lockdown under the Disaster Management Act, to which the applicant felt prejudiced by. Which is also important for us to highlight that the regulations were not meant to infringe upon the applicant's rights to do so deliberately. The applicant contends that regulations set violate her right to human dignity because they prevent her from earning an income. The respondents are aware of the effects of what the regulations would do to the marginalized, but it was necessary for the respondents to take such measures. However, the respondents provided alternatives to which the applicant could have relied on before claiming an infringement on her dignity, stating that it had been degraded because of a loss of income. In the Holabond Renaissance Foundation case, an urgent application was brought to the Constitutional Court to declare lockdown regulations unconstitutional. The applicant had submitted that the lockdown infringed upon her right to freedom of movement, healthcare, and food. The Constitutional Court dismissed the application, stating that the rights in the Bill of Rights can be limited under certain circumstances. We submit that under circumstances of a pandemic, making use of alternatives provided by the government as opposed to competing for an income was a viable option that the applicant should have considered. The applicant should consider that her right to human dignity does not rank superior to others' rights to life and the right to obtain healthcare services. The applicant had an option to seek a remedy from the government. Instead, the applicant claimed that it knew of the lockdown regulations, but it didn't know about the alternatives instituted by the government, which does not make sense to us. For a businesswoman with local and international recognition, her ignorance to what was happening around her surroundings was unreasonable and unjustified. The only human dignity that was infringed upon the applicant is her arrest for contravening lockdown regulations, as stated in State versus Makwanyane, which recognizes that imprisonment inevitably impairs a person's dignity. Furthermore, moving on to trade, the respondents submit that Section 22, the right to trade, can be limited by Section 36 of the Constitution, the law of general application. It is important to note that constitutional rights are not absolute. For rights to be limited, they need to be justifiable and reasonable in an open, democratic society based on human dignity, freedom, and equality. To determine whether the right to trade is justifiable, two questions need to be answered: whether the right to trade has been infringed by law or conduct of the respondent, which are the lockdown regulations being put into place, and if so, is the limitation justified? To answer the latter, the applicant, the right to trade has been infringed by the implementation of lockdown regulations. And to answer the former, the limitation is justified following research such as from the South African Medical Research Council and other entities, which suggest that trauma units saw about 35,000 weekly admissions. The high rise of alcohol sales means that 5,000 beds are used in admission of persons who experience violent traumas due to alcohol-related matters. The public health system is congested. However, the most reasonable means of preventing it from collapsing is taking drastic measures to curb the spread of COVID-19 by imposing restrictions on sale, dispensing, and distribution of alcohol. Section 36 lists factors that determine whether a limitation is justifiable or reasonable: the nature of the right to human dignity, the importance of the regulations, the nature and the extent of the limitation, the relationship between the limitation and the purpose, and finally, the less restrictive means. In terms of the nature of the right to human dignity, the applicant stated in their heads of arguments that committing ourselves to society founded on recognition of human rights, we are required to value human dignity and the right to life above others. In Mohammed, the court stated that whilst no right is more important than another, a limitation analysis involves balancing of means and ends. This means that all the factors are needed to balance between the limitation of the right and the purpose. The respondent contends that the drastic measures were necessary to curb the infection rate and manage the healthcare system and prevent it from collapsing. The nature of the right was against the right to life and the right to healthcare, to which the right to life and healthcare was paramount under the circumstances of the pandemic that the world was facing. The right to earn a living through the sale of alcohol when a public health system is in a crisis and is under pressure cannot be justified. Secondly, the importance of regulations. Agreeably, the regulations must serve some purpose. The regulations do not infringe the right to human dignity because they serve a purpose. They seek to minimize the pressure that hospitals get as a result of violent traumas caused by alcohol consumptions. In line with the WHO global strategy, the ban of alcohol sales has seen striking benefits and valuable lessons for regulation. And thirdly, the nature and the extent of the limitation. According to the International Covenant on Civil and Political Rights, the restriction must be necessary for the protection of one of the permissible grounds. The nature and the extent of the limitation must respond to the pressing need. This factor also considers that the limitation must be proportionate to the interest at stake and must be the least intrusive option among those that might achieve the desired result. When South Africa entered into the third week of lockdown, the president had an option of either lifting the lockdown regulations, which was mostly to extend the lockdown. The latter was applied, which is justifiable as it benefited the healthcare system by reducing the burden that alcohol consumption normally has on it. And then fourthly, the applicants contend that there is no rational connection.
Less than a minute.
The applicants contend that there is no rational connection between the means chosen and the ends. However, this does not lay true. When the ban on alcohol was introduced, 66% of trauma admissions decreased. Statistics by the South African Alcohol Alliance stated that the ban on alcohol has seen striking benefits and valuable lessons for the regulation. Drinking outlets have been associated with violent engagements now being reduced to contact crime. I would like to finish the last of, if the court pleases, of my arguments.
Thank you, Ms. Bila. You just came in on time. Couple of seconds over, but well done. Ms. Bila, I just want to find out, you indicated the rationality test, and you know the applicants are challenging that this decision to impose a ban on the sale of alcohol is rational as there are alternative means available, including, for example, applying safety measures such as have been applied by many companies in South Africa, thousands of companies. And that's the first aspect I want you to address. And the second aspect is, you quoted State versus Mkwanyane and indicated that an arrest would compromise the dignity of an individual. Are you then not opposing the expunging of the arrest warrants? So those two questions, if you can answer for me.
Okay, to address the first question, I think it's important to highlight the case of Mohammed, where gathering was prohibited because of gatherings were prohibited in mosques. And if I recall properly, they're the ones that came out with solutions that the government could make use of, but then it is not their discretion to determine what the government needs to do. What is of there's also a case also in Albert, which also stated that what is important here is the means and the ends, and the manner in which the ends is being achieved is to check. Oh,
We
yes,
lost
the
you,
case
Ms. Vila.
stated that a person seeking
Thank you, Ms. Bila. You may continue.
that the object could have been achieved it could have been achieved in a different way. And also, again, going back to the Mohammed case, what basically transpired from the case was that the Islamic community were seeking that sanitizers be put into place. But then what is of concern is that these people that come into these mosques, there's no guarantee that when they leave there, they will not have contracted the diseases, to which they will use public transport and also go back to their families. And in that sense, that will infringe on their right to life and healthcare. And then for the second question, I'm not expunging on what is it? I'm not expunging on what was the question?
The question was, are you now conceding the point that because in Mekonyane the right to dignity is infringed upon an arrest, that you made as a proposition, that you accepting that the arrest warrants be expunged, or the
No, we were not stating that the
criminal
arrest
records,
be
the
expunged.
criminal records, yes, be expunged.
Yes, it's not for them to be expunged, but then it's for the applicant to be aware that if they infringe upon lockdown regulations that have been set down by the government, obviously her right to human dignity will be infringed upon. And that is something that the state can lead her human dignity to be infringed.
Thank you, Ms. Bila. Thank you. Any other questions for Ms. Bila?
Ms. Bila, in your research, have you found that there is a link between the unintended consequences of the regulations, for example, such as loss of employment, mental health, and people being confined in spaces with abusers, and the increase in gender-based violence? And if so, how would you address the court on why then, with that in mind, the regulations should not be expunged?
If the regulations are expunged, it means that it will the lockdown will not be controlled, and it means that flattening the curve will not be achieved, because then the right to life and the right to healthcare will be affected. I believe that the position of the amicus curiae was to address the court on statistics such as gender-based violence that occurred in homes. And I believe that alcohol was one of the reasons in which contributed to such issues. And if lockdown regulations are expunged, it could increase.
Thank you, Ms. Bila.
You're talking of the regulations being declared unconstitutional?
Yes.
Okay. Any further questions for Ms. Bila?
No further questions.
No further questions, thanks.
Thank you, Ms. Bila. We'll now listen to Ms. Lee.
Good day, my justices. If it pleases the court, my justices, I will be addressing the question of the rationality of the lockdown regulations, specifically sections 24, 26.1, and section 31 of the lockdown regulations, as well as the discussion of appropriate remedy in this case. My justices, according to the Pharmaceutical Manufacturers Association of South Africa's case, the court acknowledges that rationality is a minimum requirement for the exercise of legislative power. In the De Beers case, the court held that when considering rationality, it is important that the means employed are rationally related to the purpose for which power was confirmed. Furthermore, the court held that measures need to have a rational connection to a permissible objective. The pharmaceuticals manufacturers case reinforces this, as the court held that decisions must be rationally related to the purpose for which power was given. The De Beers case also states that in the event that the regulations are attacked on the basis of its rationality, the courts are obligated to examine the means related to the objective sought to be achieved. This is usually done by the rationality test, which focuses on the evaluation between the means. In this instance, the means refers to the lockdown regulations pertaining to the sale of alcohol, the functioning of shebeens and taverns, as well as the establishment of gatherings. And the ends refers to the curbing of the spread of the virus, as well as preparing the healthcare system for a surge in infections. Therefore, my justice, we respectfully submit that sections 24, 26.1, and 31 of the lockdown regulations, which prohibit the sale of alcohol, the functioning of shebeens, as well as gatherings, are to be considered rational, as they serve a greater purpose in the national state of disaster, namely to prevent the spread of the virus, to build up an extensive public health response to the pandemic, as well as prepare the healthcare system for a surge of infections. Furthermore, as stated by the Director General in the judgment of the De Beers case, it should be noted that the regulations cannot be dismissed, as the saving of lives should take priority over freedom or the right to earn a living. My justices, when discussing an appropriate remedy, we humbly request the court for the following remedies. We request that a declaration order be drawn up stating that the level 4 lockdown regulations, specifically regulations 24, 26.1, and 31, do not infringe upon the right to human dignity. We also humbly request that the relief sought by the applicant is dismissed. In the event that the courts do not favor our response, we humbly request that a period of 3 months be awarded to amend the unconstitutional provisions. We also request that party-to-party costs be awarded.
Thank you, Ms. Lee. Ms. Lee, in terms of your last submission on the party-to-party costs, the applicant has cited authority that where a person wishes to approach a constitutional court to have a declaration on their rights, that they should not be lumped or mulcted with legal costs. And therefore they say, even if the applicant is unsuccessful, costs should not be ordered against the applicant. What is your submission in that regard?
My justice, I do acknowledge that with constitutional litigations, it has been stated, especially in the BioWatch case, that constitutional litigation, when dealing with constitutional litigations, no cost should be awarded towards either party. However, in this situation, or in this case, we see it as appropriate that if the regulations are not considered to be constitutional, that each party be awarded their own litigation costs.
So you would be amenable to each party paying their own costs?
Yes, correct.
Any further questions for Ms. Lee?
Ms. Lee, can I ask you to address the same question that I raised to you, lead counsel? whether there was any research that was done or which by your team looking at the unintended consequences of the regulations, such as indicated loss of employment, mental health, and other such things, and whether there was found to have been a link between that and gender-based violence.
My Justice, when looking at the consequences of the regulation and its relation to gender-based violence, it is important to note that the consumption of alcohol is not the only factor which relates to gender-based violence, or in this instance, intimate partner violence, and that the regulations, especially seeing as how the regulations can result in a loss of income and whatnot, it has been noted that the loss of income could add additional stress and frustration, especially to breadwinners, which are in this instance male, because it is noticed that most cases of intimate partner violence in South Africa is committed between men and women, with men being the perpetrators and women being the victims. It is noted that this loss of income could place additional stress and frustration onto the breadwinners, in this case, the males, and which could result in intimate partner violence in that sense.
No more questions on my side.
Thank
No
you.
questions for you, Ms. Bila. Thank you.
Thank you, Ms. Bila. Okay, we have now heard all the parties. We as justices will have to go and deliberate on the decision and then join you in session 3. I think the coordinator and the registrar may want to say some things at this stage.
Yes, thank you, Advocate Bava. I would just like to say to everyone, I know that we will be sending the link to the respective groups in terms of the participants, but in terms of the people in the gallery that have joined us, graciously so, please keep an eye on the SABWiL pages. The link will be posted there for the third session. That's all from my side. Thank you.
Okay, then we will be ending this session, and the justices will now be deliberating on this aspect, and then we will rejoin you in terms of the third session at 1:45. Is that correct?
Yes.
Yes.
Correct.
Okay. Thank you very much, everyone. Now we will go and deliberate and let you know what our decision is.
Thank you.
Thank you.
Thank you.
Bye.
Bye.